Good morning, friends. I am discussing important topic relating to Article 226 of the Constitution of India. The case is Director of Agriculture versus M.B. Ramachandran. The question before the Supreme Court is, can a writ petition under Article 226 of the Constitution of India for recovery of money under the bills and invoices should be entertained by the High Courts, more particularly when in fact original writ petitioner availed the remedy before civil court by filing civil suit which was dismissed in default. So to answer this question, we have to firstly know what the facts of the case are. The background facts are Mr. M.B. Ramachandran filed a writ petition under Article 226 of the Constitution of India before the High Court of Kerala, seeking a direction to the Director of Agriculture to settle the bills invoices of the petitioner. The single judge of High Court allowed the writ petition and directed the Director of Agriculture to settle the bills of the petitioner. Director of Agriculture filed an appeal before the divisional bench of the High Court, which was dismissed. The order of single judge stood confirmed by the divisional bench. So, consequently, he was having no relief than to approach the Honorable Supreme Court. So, the Director of Agriculture preferred an appeal before the Supreme Court. Now, how the Supreme Court solved this problem, I am discussing with you. The bench observed that in 2017, the original writ petitioner had filed a civil suit before the district court for recovery of money allegedly due and payable under the bills invoices, and same was right remedy available to him. However, the civil suit was dismissed in default. The respondent took steps to restore the suit and withdraw it. But prior to the same, the writ petition was filed before the High Court. The bench reprimanded the High Court's decision to entertain the writ petition and observed as under. We fail to appreciate how the writ petition before the learned single judge could have been entertained for recovery of money alleged to have been due and payable under the bills invoices. The learned single judge ought now to have entertained the writ petition under Article 226 of the Constitution of India for recovery of money under the bills invoices, more particularly when in fact the original writ petitioner availed the remedy before civil court and filed civil suit, which came to be dismissed in default. The bench held that writ petitions for recovery of money due under bills invoices cannot be entertained. Accordingly, the orders passed by the single judge and divisional bench allowing the writ petition have been set aside. The respondent has been granted liberty to pursue its remedy before the civil court through restoration of civil suit. The trial court has been directed to restore the respondent suit if an application for restoration is made within 6 months. Thank you for listening.